And in Cherokee County, where they brought all these charges against me, they would not file my affidavits in the county clerk and recorder. No problem. I go one county over to Smith County, and they'd already been sued about that, and they lost. So when I come in there and I put it on their desk, no problem, Mr. Fox. They click their heels, smile, take the cash, and say thank you. That's how that goes. Okay? So if you can't get success in one county, you find one where you can get success. And if you go to too many, and if you go to the one you're in 4 other counties, just contact me and we'll find a county for you. Because there are some that will file anything, and the reason they file it is because they've been sued and lost.
Now with property records, you got to be in the same county you're in.
Right, property records. But if you've got some documents that you want to file and you want to declare, like say this locksmith, he could done up his stuff, declare what happened there, file it as an affidavit in the public record, and if it had gone beyond the grand jury thing, he could have brought it into court and filed it into court, and it would have all the stuff right on at the top of it that it was filed in the county clerk and recorder's office, and they should recognize it as a ticking time bomb, basically.
Why is it more powerful? Because nobody rebutted it at that
Exactly, because it's a matter of public record when you file it in there, and it's like a bigger public record than the narrow confines of the case. It all comes down to it, though, that an affidavit is the closest thing to testimony. But like I say, it's still, all affidavits are hearsay until they are testified to. But if there's no counter affidavit, they got a problem, because your stuff is going to stand then. Now,
could you give us the elements of an affidavit real quick before we start reading one?
well, you have to declare who you are, and that you have personal knowledge, that your age of majority, that you're mentally competent, and all that stuff is in those encyclopedias, by the way, amateur or corpus juris, and you might want to familiarize yourself with that stuff, because those are like the Encyclopedia Britannica of law, and they will give you a whole bunch of state cases or even federal cases where certain issues have already been adjudicated. And I'm mentioning this not just because of affidavits, because of anything that you want to work with and do. You might want to look it up there, because you can pick up information that reinforces what you're trying to accomplish. Does that make sense, folks? Okay. I have, with the affidavit like that I did with Dr. Brooks, or this one that I did for Tim and Don Patton, I get this all in this one paragraph right here. Can you all see this?
Yeah.
I say the white and black.
Yeah, the white and black. Okay. Well, this part up here is called the style of the case for those who are novices. Right here, this part where it says the court, and it says United States of America versus Tim and Don, and the case number. This is a federal format. The state format looks a little bit different, but it has this information in it, and it's called the style of the case, okay? And it tells the clerk, basically that it's this court, it's this case number, these parties, okay? Then I've got my title of the document, which I'm I'm just kind of noisy that way. You know, so that's, I make this gigantic bold letters. And then this part here is what qualifies the affidavit in this first paragraph here. And then I go on to facts. Okay? Now, at the end of this thing, I have a paragraph over here, which I make my last paragraph. And this is the paragraph that protects you. And what it says here is this: I'm not an expert in the law, however, I do know right from wrong. If there is any human being damaged by any statements herein, if he will inform me by facts, I will sincerely make every effort to amend my ways. I hereby and herein reserve the right to amend and make amendment to this document as necessary in order that the truth may be ascertained and proceedings justly determined. That phrase, that the truth be ascertained and proceedings justly determined, is taken right out of the rules of evidence. And before that, I'm saying I reserve the right to amend. So if they say, Mr. Fox, you've got something in paragraph 9 that's wrong, and it's falsification of the record, and this is virtually testimony, and we'd like to prosecute you for this falsification of the record. My comeback on that is, now it's never happened, by the way, but my comeback would be that not a paragraph, not a sentence, not a phrase, not a single word is to be taken out of context. The affidavit is to be taken as a whole, which includes the last paragraph where I say, I reserve the right to amend. Right? Now, if you saw somebody, for instance, if you saw somebody squeeze on the trigger with a big Colt 45, and there's a mighty bang, and flames come out of the barrel, and this other guy goes back and blood and guts fly out of his back. Now, what does that look like to you? Yeah, you saw the guy who killed him. Now, what if this was in front of the saloon in Knott's Berry Farm, where they do these things routinely, except that the blood and guts don't come flying out of the guy? But you saw it, and it looks like murder. It looks like that guy who squeezed the trigger shot and killed that other guy. But you don't know whether there was simultaneously a sniper 1,000 yards away. Right? So were you perjuring yourself when you described what you saw and your conclusion? I don't think so. You getting the picture? So anybody could make a mistake in an affidavit. And sometimes it's a typographical mistake that they never saw. Sometimes it's something else. But this last paragraph is to protect you. So continuing here, about after the truth may be ascertained and proceedings justly determined, and you just can't argue with that. It's part of their own rules of evidence. If the parties given notice by means of this document have information that would controvert and overcome this affidavit, please advise me in a written affidavit form within 30 days from receipt hereof, providing me with your counter affidavit, proving with particularity by stating all requisite actual evidentiary fact and all requisite actual law, not merely the ultimate facts or conclusions of law, that this affidavit statement is substantially and materially false, sufficiently to change materially my status and factual declarations. Your silence stands as consent to and tacit approval of the factual declarations herein being established as fact as a matter of law. They're already warned. Okay? May the will of our Heavenly Father Yavah, through the power and authority of the blood of His Son Yeshua, be done on earth as it is in heaven. And Yeshua, by the way, is it's Jesus Christ in the Greek and Yeshua in the Hebrew. Okay? So, that paragraph will protect you. And I think that's important to know.
Yeah.
So, and what I do in the computer is I set these things up like a template, and I have this, if I've got a case, I have this stuff with the case number and everything. And I leave the title blank. I've got this paragraph because that's always standard. And the ending with the last paragraph and the signature stuff, that's all standard. And then I can fill in the meat and potatoes of anything else that I want to put in here. And a lot of times I write up the document and don't put a title until I'm finished. Law is such simple stuff when you get right down to it. You've got something in your head, you need to express it, you start putting it down in writing, and it starts becoming clear, as you formulate it on paper. And when you're done, you look at it and you say, well, this needs to be called such and such. Does that make sense? And so that's how it goes.
Yeah, Robert, really fantastic, but could we just bring our thumb drives tomorrow and get all these templates on our thumb drives?
We could get some, yeah.
We got a computer guy, a couple of computer guys that can do the transfer for us. It's up to you.
Okay.
We'll make you an offer you can't refuse.
Put that in an affidavit, Berger.
So, in Missouri, I had a traffic thing, and, these judges would try and arraign me, and I don't arraign very well. In the federal court system, the Richardson police arrested me in 1990, and it's a published case, and the thing is that it just says, Fox was arrested October 9th, blah, blah, blah. Continues on for a bit, and then it says, the court entered a plea of not guilty for Mr. Fox, who defended himself. It doesn't say that I ever entered a plea of not guilty, and they have the date there. I forget what date it was, but they have the date there, and the thing is that it was 184 days from arrest to arraignment. And it still was not a plea by me. Okay. So in Missouri, I wasn't going along with their arraignment there either. And then they'd start trying to get funky with me. And so I did up affidavits declaring that they were, liars and thieves and so on. And I blew off every judge in the county. And the Supreme Court of Missouri had to appoint a special judge from another county over a traffic ticket. and then by that time, the prosecutor was absolutely livid. And he came in and he says, "We have it all right here, Your Honor." He called the honorable judges of the great state of Missouri. He called them liars and thieves. We got it here. And he got his signature and his thumbprint seal and all of this. And carrying on, and they said, "Excuse me, those affidavits are all over 30 days uncontested. They're undisputed fact as a matter of law."
Yeah.
This guy wanted to nail me for major contempt. He would have liked to see me put away for years. You know? He couldn't make it to first base because those affidavits were uncontested. And him ranting and raving in the courtroom didn't change that. There was a guy who called me from federal prison, and he said he's sending me some of his stuff, and then he'd call me and check with me after. So he sent me his stuff, and then he calls me afterwards, and he says, well, what do you think? And I said, well, first off, I think you're a genius. And I think that your work is really incredible. And he said, yeah, but I'm still in prison. and I said, well, that's because you're doing your stuff as motions, and you need to do them as affidavits. And I explained to him some of the stuff I've explained to you here. So a few months go by, doorbell rings, this guy's on the doorstep, stuffs some cash in my shirt pocket, takes me out for a bite to eat, and tells me how much he appreciates the fact that he gave the feds back 250 years of prison time. So, I think that affidavits work. And like I said, I've run into people who, you know,
Do you have to serve an affidavit on, who you're...
okay, the answer to that is yes and no. Depends on what the document is, okay?
What was the question for the camera?
Okay, for the people on the video, and the question was, do you have to serve the affidavit on the other party? And I said the answer is yes and no. Here's this one, and I'm giving administrative notice and demand presented by affidavit of amicus curiae, Robert J. Adams. Now this one gets filed in the court, and on the very last page, we have what's called a certificate of service, and that's where you declare or certify that you have given it to the other party or parties. In this case, being a criminal case, the other party is the U.S. attorney or his assistant. Okay? In a civil case, there might be 20 other parties or even 100 other parties, and you have to list them, and you have to certify with your signature that you have sent the information to each and every one of them. Now, so far, I'm telling you that you have to send a copy to everyone. Now, the difference comes when you have a document like a habeas corpus. A habeas corpus gets filed with the court, and that's it. In the style of the case up here at the top, is if you're doing it for yourself, you put ex parte and then your name. Ex parte means, well, let me say this. We'll just draw a diagram here so that everybody can get this. In a criminal case, for instance, you have this kind of arrangement. You got the judge here, there's me, there's the prosecutor. When anyone in this triangle does anything, he's supposed to notify everyone. So if the prosecutor makes a document, he files it with the court clerk and that gets it to the judge. But he also has an obligation to send me a copy. When I make a document, I have to send him a copy, and I have to certify on the document, like he has to too, certify on the document, that he has given me a copy. I have to certify that I've given him a copy, and I certify it to the court clerk who gives it to the judge. So there's nothing happening, and the judge, Even if the judge issues an order, he has to send a copy to me, and he has to send a copy to the prosecutor. And this is so that there's no hanky-panky going on, okay? Because it's called ex parte communications if this guy talks to the judge privately without me. Or if I try and talk to the judge, maybe to give him a bribe or something, and the prosecutor's left out of the loop, of course, okay? Well, this is in theory how the system maintains some sort of integrity. The reality is that the prosecutor and the judge, they go to the same parties together. They're constantly socializing with one another, and their communications are always going, and you are left out of the loop, kind of thing. And that's the reality. Now, there are some judges with integrity. I can't say that this is always the case, but
We're still voting for him.
they do what's good for them. In Dallas, I knew an attorney by the name of Robert Rose, and things developed. Let me say this. I had a friend whose whining and wenching budget was like $20,000 a month. Okay? And he's a young fellow, he had a hot Mercedes convertible, and then, when they'd go out and party with the babes from the Topless Bar and the rest of that, and they'd have the penthouse suite at the Sheraton and all that stuff. Anyway, he's the one that introduced me to Robert Rose, and I visited Robert Rose at his place, and his cash is stacked up on the table and the rest of that. He got one guy off for having, I think, 1,000 or 2,000 pounds of marijuana in his living room. Got him off. It was for personal use. But then things kind of unraveled because this kind of communication here, what the deal was is that, there'd be these drug cases, and Robert Rose would get a large amount of money, and the judge would get a chunk, and people would get set free, and then they'd all go and party in the Bahamas. Anyway, reality can be a little bit different. But anyway, the FBI caught up with him, and they put a stop to that. And Robert Rose turned state's evidence against a whole bunch of judges in Dallas taking bribes, and it was a big problem. Big problem. Let's see. I'm continuing to go over these, what I call powerful tools, and we're going to do some more of that in just a second. And also, I'm going to go, what I intend to do is to show you from the process, the criminal process, from indictment, arraignment, pretrial, trial, and allocution, appeal, etc., habeas corpus, all that, and how you can win at every step of the proceedings. Okay? Something I forgot to share with you, I got off on one of those tangents. Now, that federal case in 1990-91, when they sent me to the federal torture facility in Springfield, Missouri, when I came back from that event, Federal Judge Barefoot Sanders and I had a flat-out screaming match, both of us as loud as we could possibly go. Him demanding that I have an attorney, and me telling him in no uncertain terms I absolutely was not going to have one. And the screaming and yelling was going nowhere, so he finally said, "Marshals, remove this man." and I was bodily removed from the courtroom. A week later, I'd already filed some paperwork that declared my position, and I was brought back into court, and I prevailed in that argument. So I was going to trial with no attorney, no standby attorney, no attorney, period. So, and in the jail cell, there was a funny, you want me to share it with you?
Sure.
Okay, so I'm in this lockup at Mansfield, Texas, contracted with the feds to federal pretrial detainees. Well, one of my cellmates is a fellow by the name of Mike Wilson. He had been 10 years top prosecutor in Dallas, followed by 10 years top federal criminal defense attorney. If you had a federal indictment and called him up, it was $100,000 right off the top, okay? And there he was my cellmate. You know? And what was $100,000 in the free world was chocolate bars in the jail. So we had some interesting discussions, and he was you know, he had a head on his shoulders. He understood a lot of stuff. The interesting thing is that he and I were being prosecuted by a female prosecutor, both of us prosecuted by the same female prosecutor, and he's the one who trained her. And so, as things progressed, you know, I had filed the correct lawful winning arguments again and again and again and again. This is the time when I didn't understand affidavits and I was doing motions. And they were denied every time. So here's this judge, he's denying all the correct lawful winning arguments. And as I get close to trial, I declared that I was waiving the jury, which meant that the judge was going to have to decide the case. And my cellmate said, "You are crazy." and my contention was that you can't hold the jury to the law, but you can hold the judge to the law. So, and the law was on my side as far as I was concerned. So that's the way I was going to do it. And I filed my documents, and the judge had ordered the prosecutor, this female prosecutor that was prosecuting me and Mike Wilson, he had ordered her to answer. So the day came, I'm sitting in the cell, I get the mail, and I got her a 5-page answer, and she's making an argument in one direction on page 1 and the exact opposite on page 2, and back somewhere else on page 3 and elsewhere on page 4. And I'm sitting there looking at this stuff, and I think, am I losing my mind? And I crossed the way in the pod there to Mike Wilson. I said, "You trained her. Do you understand this stuff?" And he looked at it, he said, "She's okay until she runs into a detour, and then forget it." You know? And he said, he said, "You're right." He said, "This is completely gibberish and it's incomprehensible, you know." And so we go to trial, and Barefoot Sanders knew what was going to happen. And the way the trial starts up, you know, he comes in, he says, "We're on the record, case number such and such, United States of America versus Robert Fox. And is the government ready to proceed?" "Yes, Your Honor." "Mr. Fox, you ready to proceed?" "No." "Why not?" "Well, I have motions before the court and they've been unanswered." He said, well, would you like to argue your motions? I said, I certainly would. He said, very well, proceed, Mr. Fox. So I argued, I got 2 federal felonies. One is forging and counterfeiting entry documents, the other one's diplomatic impersonation. And so I argued the both of them, but when I finished arguing the first one, the forging and counterfeiting entry documents, he just said, agreed, case dismissed on that one. He said, on the other one, we're going to trial. This was just to save face. I had them beat on both. Okay? Now, the thing is that forging and counterfeiting entry documents arose because I made my own passport. Okay? Now, you're getting a kick out of that one. Well, the thing is, it wasn't against the law. Now, if I made a United States passport, that would be different. But what I did was, I made a Kingdom of Israel passport, like from the Bible. Not the Israel in the Middle East, but the one from the Bible, the Kingdom of Israel. Okay? There's no king over there. They have a parliament. They don't call it that. They call it, what do they call it? Knesset or something. Anyway, the charge, and this is when they come against you, you've got to keep your wits about you. Okay? I was accused of forging and counterfeiting entry documents because I made a passport. But that statute, entry documents, that statute applies only to the Immigration and Naturalization Service and the documents they produce. And they produce immigrant visas, non-immigrant visas, student visas, alien registration cards, border crossing cards, that stuff. Even housewives know that passports come from the State Department. But they accused me of something that was only and specifically limited to immigration and naturalization. And they lost. So, and the reality was, as far as I'm concerned, they couldn't win anyway because I didn't do anything wrong. Now, if I'd made a French passport or a German passport or Italian passport or a United States passport, that would be different. But how are they going to have a complaining party? Is God going to complain? I didn't hear that. I dedicated my life. I mean, I'm the firstborn, and my parents are dead, and my parents died when I was 15, and I'm consecrated to His service. So, it didn't seem unusual to me to make a Kingdom of Israel passport. And the only job you're offered in there is, the only position you're offered is as an ambassador to carry the good news of the gospel. And I went out and bought cases of Bibles, cases of concordances, printed up hundreds of photocopies of biblical law and everything else, went out, and was promptly arrested by the Richardson police. And anyway, the published opinion in the case, I'm getting ahead of myself again. So we went to trial on the diplomatic impersonation. The government puts on their case. They got their witnesses and evidence and testimony and all that. And after they've done everything that they can, they say the government rests. And Barefoot Sanders says, well, Mr. Fox, you can put on your witnesses now. I said, no, I've already won. He said, agreed. That part there, when the government rests, whether it's a state case, they say the state rests, or the federals, they say the government rests. When that part of the trial happens, that's called a prima facie break. And what you can do is move the court to dismiss the whole thing if you've got some reasonable grounds. Okay? And I had grounds.
Doesn't that mean a motion?
Well, you could say that it means a motion. In their vernacular, they would call it a motion. It's called a a motion for directed verdict, or, you know, that kind of thing. But you can do it by affidavit and say, directed verdict as presented by, you know, your name and by affidavit, you know. In any event, if you ever get to that position, you can also ask the court for time to produce your document, to you know, put it in writing what you need to do. And they might give you an hour or two break, or if it's, you know, 4 o'clock in the afternoon already, the judge might say, we're adjourned until tomorrow. We'll hear your motion for directed verdict at that time. Anyway, that's a time when you can win at the trial, and that's exactly what I did, and that's exactly what happened. Now, the interesting thing is, well, let me say this. That case is a published case in the federal law books from coast to coast. In addition to that, I hit the front page of the Dallas newspaper in full color, the front page the next day. And in short order, the case was cited in the United States Code Annotated. And for the newbies, the United States Code is all the laws of the United States arranged under 50 titles. Like Title 8 is immigration, Title 26 is taxes, Title 50 is war, Title 18 is criminal. Well, my case was cited under Title 18 because it was a criminal case, and they have the statute, and underneath the statute, they'll put 2, 3, 4, 5 cases, just a sprinkle of the absolute landmark cases that have been litigated regarding that particular statute. And my case was right there. And that is the outer limits of the legal stratosphere. And you could call all the attorneys you want in Phoenix and ask how many cases they got cited in the United States Code Annotated. And, you know, you'll hear them laugh because it's, you know, it's almost, you know, it's way out there, way out there. Yes.
What statute was that?
Okay, it was 18 USC 1546A. It is not there now.
Oh.
It was what they did. See, when I won that case, I mean, you may be able to get it in the archives, and certainly if you had your congressman or something, if it was serious enough interest to you, if you had your congressman check it out. It happened. It's there. It was there. But what happened is, like, what I was told happened anyway. A student from Notre Dame University of Law explained to me that he studied my case, and that what happened is my case opened the floodgates, and all kinds of other people won their cases because of my case. And one of the things was Paul Revere, the Kingdom of Heaven Church in Sublimity, Oregon. They were issuing passports, and they cite my case as their cause for winning, you know, and for doing the right thing, you know. And so Congress took such a butt kicking in the whole deal, they went ahead and changed the law. Well, that eliminated my case from those cited right under it, and they don't have to change the law substantially, just change a few words, and it's all of a sudden all new, and those cases get into the trash barrel. So that's basically what happened there. But there was with the Southern Poverty Law Center, I don't know if you ever heard of them. Anyway, they had a Professor Susskind, and he did up a thing. They had a disc, and I guess maybe it was a book or something. Idiot Legal Arguments. And I was in there. And the guy never read the case, because if he'd read it, he'd know that I won. So how is it an idiot legal argument to win?
He was talking about the court.
Okay. Mark says he was talking about the court. Okay. So, Mr. Heitman, you wanted to say something about the email from what's his name, the attorney?
Bob Hurt.
Oh, it was the attorney,
Tommy Cryer.
yeah,
Tommy Cryer, yeah.
Yeah. You want to say a word or two, or you?
I can, but you read it, so you might as well propose it if you want to.
Oh,
Say
okay.
a word or two about it.
Okay, well, Susie knows about it, and a bunch of people know about it, and I don't know, you want to hear about that?
Yes.
Okay, so, this attorney, Tom Cryer, in Louisiana, wrote something about this seminar because he got wind of it. And,
First of all, Tommy Cryer is considered by this group down there as one of the experts that we should all go out and get us an attorney, because Tommy Cryer is now on the opposite side because he got
Can you-
the bar.
they want to hear it all on the microphone.
Okay.
Start over.
Well, this guy, Robert Fox, you sure don't want to get him on your tube, because every morning he's going to have a list of junk like this, okay, about 7 or 8 inches of anything that he might be sent. And I'm sure the man doesn't have time to read it all, but he sends it out. And he just absolutely pulverizes your morning, because it's going to take you all morning to sort out and get rid of it. But he's a guy that's collecting donations for his bar association honkies that want everybody to go to law school. And he's got a scholarship deal going on. Well, that's Bob Hurt, and one of the hotshots is this guy named Tommy Cryer from Shreveport, I believe it is, Louisiana. And he, I believe, got disbarred, and he was out running around the country collecting money for talking about how you should do this and how you should do that. And I'm wondering how he knows all this when he couldn't get himself off. So, anyway, he just heard about Robert Fox got on this Bob Hurt list for some reason. I don't know who put it in there, but somebody put it in.
Susie put it in.
Seminar.
Susie put it in that there's going to be a seminar.
Yeah.
And Bob Hurt put it out on the internet, and then Tommy Cryer, the attorney,
Had to make his little,
had
put in his 2 cents.
had to put in his 2 cents, and he said that I'm certifiable, and that I was responsible for this problem.
Well, he said you were a certified lunatic in that thing. But anyway, certified lunatics hasn't had a loss, and Tommy Cryer hasn't had a win. So anyway, he's putting out this nonsense, and at first you think the guy really knows what he's doing, until you go over the whole thing and analyze the document. You have to analyze it on paragraph by paragraph, and all it's doing is criticizing somebody to support this Bob Hurt's junk, and it's just plain slanderous nonsense, my opinion, you know. That's what I look at it as. So I brought a copy of it for him to read, and I think he got a kick out of it, so I'm passing it on to him. But this kind of stuff can happen to anybody. It happens in courts all the time. I'm being called a vexed litigator because a guy, they had too many cases. And I did do David Miller stuff. I don't know if y'all know what David Miller is. David Miller is a correct sentence structure, communication, syntax authority.
Let go of the microphone, please. Let go of the microphone.
Oh, okay. David Miller is a a metallurgical engineer, I'm a mining engineer, and I have a good relationship with him. I do understand now what he's doing, because I learned how to do it. I see nothing wrong with what he's doing. If the language is not correct, his argument is, if the language is not correct, how can the case be correct? That's a good philosophy, but they sure don't want to hear that because they can't win against him. Absolutely cannot win against him. Because if you don't express the language in the correct sentence structure and you're using the truth, and the truth lies in the government styles manual, it's there. You have to have, in the truth language, you have to have two prepositional phrases. We don't use prepositional phrases. Neither did Russia. Russia, if you started back in the Russian language, has, and most languages have prepositional phrases, because a prepositional phrase has to have two nouns. And it has to have one meaning. It has to be able to be read frontwards and backwards and mean the same thing. And it has to have no less than 13 words. Now you try to put that together and use the language that we got, and you have to just forget what the dictionary that has all the D words in it, because DE is a negative term. There isn't one word under D that starts with DE. It's not a negative phrase. It's a negative phrase, it's not true. You see? So that was his argument. Really didn't like that. So they shoved this thing up to a guy named Quackenbush. He has the right name. He's a federal judge up in Spokane. He's got the right name. Well, Judge Quackenbush immediately called me a vexing litigator. I don't know where he got his facts from, but I'm going to find out next time I go to court, because now the attorney picks it up. First, the state judge picked up that I'm a kook. Everything was gobbledygook, and everything was gibberish, because I was using this. And he found against me for all these various things, and 3 of them did that. And I've been through 4 state judges, now I'm in federal court. But anyway, the thing that they're coming up with now is the chief federal judge of the state of Idaho is now calling me a vexing litigator. Where did he get it from? He got it from the attorney. And the attorney got it from who? He got it from Quackenbush. And I said, where on the record do you find any competent fact testimony that allows you to call me anything? And that hasn't gone to court, but it's right here in the document I'm going to put on the court. And I expect to get a big kick out of that one, because there's nothing they can do about it. Absolutely, because they have no fact witness testimony. Another thing about affidavits that I happen to learn about is an affidavit is worthless unless you testify to it. Or you qualify it, like you said. You qualify it, you must answer in 30 days. You now have sent them an offer to contract. If you have an offer to contract and they don't respond, bingo, they're dead. But if you just send an affidavit in, any kind of affidavit, you can make the affidavit. But if you don't testify to that affidavit, and I experienced this in this case, because I have 2 engineers, and being an engineer, I have no trouble knowing this because I developed lots of subdivisions. And a subdivision cannot have more than 1 protective covenant on it. If it does have more, it's ludicrous. You know, it's ambiguous. You're sitting here with one that says you got to have 50% rocks in the front of your yard. This one over here says you got to have 90% grass. And you can't have 50% rocks and have 90% grass. So this guy over here gets one set, and this guy gets another set. Now they have a war. You can't have that. So in the county commission, when they put their stamps on the subdivision plat, and they got a whole bunch of little stamps going around, they certify that they have covenants on that. There's only 1 set. And in my case, that 1 set is neither one of the kind they put in. They put 2 sets in. So that's another argument. But to come back down to this, if this guy puts in 2 sets of covenants, wouldn't you suspect that that's a fraud on the court if he brings his case for that? It certainly is fraud on the court. I mean, a fraudulent act, a misrepresentation of material facts, is it not? Okay. And that's where we're going. Tommy Cryer if you read this document and the letter, he's got it, right, I just made a copy for his benefit. You have to look at it and analyze it, and you see it's just a bunch of slander. And why these people want to do this, and why they want to promote attorneys, is beyond me. Because an attorney is a man who likes to make a living by his wit. And if you believe that, then he has to be a liar, cheat, and sneak. He can't be anything else but. That's my.
Okay, thank you. So,
You made a statement that an affidavit is not any good unless you testify to it.
okay, it's what I was explaining earlier. All affidavits are hearsay until they're testified to.
I understand that.
Okay, now, the thing is that what I do to them, like I have my own script, like I was explaining.
Right.
I'm standing up to accurately state the facts I may subject myself to penalties for perjury under the laws of the United States of America. Having qualified my testimony here today, I hereby state for the record, and I go into my stuff. Now, if I've got a bunch of affidavits on the record, I declare that all the affidavits I've filed in this case are true, correct, and accurate. Now, I've testified to all of it.
That's a separate action.
No, I think you're a bit confused.
I am.
What, yeah, if you put in an affidavit and you state these are the facts, okay? And at the beginning of the affidavit, you say you're over 18, you're qualified to testify, if called upon, you must have that in. If called upon to testify, I agree, I will testify, and there's a couple others.
Oh, we're coming to the end of we're finished?
Yeah, it's break time, you just, anytime anybody wants to have a break.
break time.
Break time. We're gonna have vegetables for about 10-15 minutes. We got some vegetable trays out here, some drinks, coffee, whatever you like, so go to the bathroom, take a break.
At the end of the thing, he qualifies this by saying, if you don't respond in 30 days, you agree to what I say.
Okay, got that.
That makes a difference.
Is that what you call testimony?
No.
Testimony is stated.
I'll come back.
The testimony is verbal in the court, under oath.
I got it.
Robert,
But I make my own thing.
just so we're all clear about this, the 30 days, is that a statutory requirement? Automatically they have to respond within 30 days or it's gone? Or do you have to put it in the affidavit? Because that's what I think he's saying. It has to be incorporated and we're in disagreement.
Okay, you can put whatever you want in there. In a criminal.
Quiet, please.
Are we still on the record?
Yes.
Trying to be. We're trying to be.
Huh?
We're trying to be.
Okay, well, the question was about 30 days, and the answer is, motion practice in a criminal case is 10 days, motion practice in the in the civil case is 20 days, summary judgment is 21 days, common law is 30. If you've got 30 days and don't answer in the 30 days, you're toast at the common law, okay? And that's where it is. And so even I might be in a situation where I really desperately need them to answer within 10 days, say trial is going to start in 10 days, I nevertheless put 30 days there. Reason being, even if they were to convict me at trial, if they don't answer the affidavit by 30 days, they are finished anyway. So the trial has to be, reversed because, they didn't do the right thing.
Yeah, I think the question was, is there a statutory law that says 30 days it becomes valid?
It's
All of these
contract.
court cases.
No.
It's a matter of contract.
Okay.
You offered him a contract.
That's why he's doing the 30 days, so he creates a contract,
All right.
because it's not statutorily presented.
That's what the banks do in non-judicial
Right.
processes.
That's why. He's
There is case law.
adding punching power.
There is
That's all.
case
And
law,
I'm assuming that
and
UCC has
it's
the
Morris
same
versus
issue.
National Cash Register and other cases, that, 30 days, and an affidavit on the record for 30 days becomes fact.
It's just like you said, if you don't respond in 30 days, you owe me a $500. If you don't respond in that 30 days, I don't care what it is, you agreed to that $500 and you gotta pay it. That's exactly what it is. It's the same thing. Anytime somebody sends you a document, this is called the commercial affidavit process, by the way. And if somebody sends you something and requires you to respond, you have an obligation to respond to that document. If you don't respond to that document, you're hooked.
Well, not
You don't
necessarily.
even have to go to court, you're hooked.
Not necessarily.
You're, you've got an uphill battle to beat it.
We're giving legal advice now. See, that's not necessarily true. We'll go over it. Yeah, okay. Thank you.